Legal questions answered by our experts, the attorneys with Josh Wright from the Hollis, Wright & Couch Law Firm, and host David Lamb.
Hello and welcome in to the attorneys. We appreciate you being with us tonight. The whole goal of this program is to get your tough legal questions answered by a panel of experts. For that to take place, you got to get your questions to us, and we sure try to make that easy. You can call, text, or email all throughout this program. Get that information to us, and we'll do our best to get those responded to our panel of experts. Leading our discussion tonight, Josh Wright is from the firm of Hollis, Wright & Couch. Good to see you, Josh.
You too. You doing all right?
Doing all right.
Good,
yes,
good.
Sir.
You know, David, we've got an interesting topic today. There's a statistic from the Department of Justice. In 2011, $2.8 billion were recovered for fraud against the government. We're going to be talking about whistleblower suits, or what's called qui tam suits today. When you talk about those types of topics, these are complicated cases, and there are only a handful of lawyers that really actively litigate in these. And Henry Frohsin, who is with us today, thank you for being here.
Delighted.
Is one of these guys. And he's got a firm here, Frohsin and Barger. Tell us just initially a little bit about your practice. You come from the U.S. Attorney's Office years ago.
Indeed.
And have experience on the prosecutorial side, but also now litigate these cases from a whistleblower perspective.
Right. Josh, we do have a great deal of experience in the federal realm. I was an assistant United States attorney for 15 years, and I've been practicing law for 45 years, all as a litigator. This is an area that is, as you said, is highly complicated. It is meant to be that way because it's one of the few cases that the government has said a person is not free to file their own lawsuit pro se or representing themselves. They have to have an attorney to file a qui tam action. And qui tam is a very interesting concept in and of itself because it's timely because it goes back to the Civil War, 1863, and with the advent of Lincoln being in the movie house, it's sort of timely because it's called the Lincoln Law. And what happened was people were selling diseased horses and mules to the Union Army. And of course they didn't have the resources to go after these fraudulent merchants. So Congress enacted a bill which is called the False Claims Act, which is still alive and well here in 2013. And it absolutely prohibits anyone who receives a government payment for filing falsely to receive that payment.
And let's drill down a little bit. When we're talking about a whistleblower, I think people probably generally get the concept, but these are generally individuals who have knowledge of a fraud being committed against the government, and they are the ones filing the claim through a lawyer. Is that how it generally works?
Absolutely. Let me explain an oversight of how this generally works. Usually an employee, or more often an ex-employee of a company who has seen fraudulent practices, they are filing, upcoding, or causing the government to pay more to the company than is appropriate. So, generally speaking, that person may go to management and say, hey, we're doing it wrong, you shouldn't do this. The majority of those companies would say, okay, we'll get it right. Some companies, though, fire the employee, and the employee typically, as redress, wants to correct the situation. So under the False Claims Act, there cannot be a retaliatory discharge. You cannot fire an employee for bringing fraud to the attention of management, number one. But number two, they come to a lawyer, and the lawyer's duty, of course, is to investigate and to try to find out what's going on. Those facts that and we call these folks relators, unlike any other aspect of the law, they're not plaintiffs, they act as plaintiffs. But we call them relators because they're going to relate material facts and circumstances that suggest that the company that they're working for or know about or committing fraudulent acts.
Can you, to put it kind of a real-world scenario for us, and feel free to change the names or whatever, but in your practice, an example case where that took place. I mean, what kind of, give us a real-world example of that.
Well, one case, which is of public record, is where a nurse saw that their employer was admitting inappropriate patients to a hospice program. Medicare has very strict standards about who can be enrolled in hospice. This particular company didn't care as long as they could get paid for the census of hospice patients. So the employee came to us, we filed the suit. The suit, unlike other suits, has to be filed under seal. And that means nobody can know of the existence of the lawsuit until the court unseals the complaint. So, to take this example, the nurse comes, we investigate, we find as best we can, because we can't go and talk to the employer and say, hey, we know what you're doing, but we look at documents, we try and see what's going on. And if we think that the action is meritorious, then we draft the complaint, we file it in the federal district court, and it goes under seal. Now, the law says that it stays under seal for a period of 60 days to permit the government to determine whether or not it is valid, whether or not it's a meritorious claim. That's what the law says. In actuality, the government will delay its investigation an average of 2 to 3 years before the government makes a decision whether or not to intervene in the action. The False Claims Act says the government has to investigate and has to make a decision whether or not to intervene. Okay? Now, if the government decides to intervene, essentially it takes over the case from the whistleblower relator.
Right.
The whistleblower relator, though, is not finished, because the relator has to work with the government to try and educate the investigators, the Department of Justice employees, attorneys, and to help the government bring the case to fruition.
These whistleblowers, too, now, this can be very lucrative for the whistleblower. They also can be compensated throughout these cases. Another couple quick examples, too. I know we're probably going to be going to commercial break here, but another quick examples, hauling freight for the U.S. government. If you're hauling freight and you're upcharging, if you've got a contractual relationship to provide a product on behalf of the government and you're creating fraudulent POs and invoices, or you're charging more than the market rate should dictate, those are just some of the examples. Pretty much any fraud committed on the government that requires the government and therefore the taxpayers to pay more money than they should have under a regular bargain for transaction is arguably actionable as a QTAM action.
Why the attraction? Because I see by the numbers are astounding. Is the attraction to pursue fraudulent activity because it is so difficult to regulate, so difficult to catch, and it's so complex? Is that a part of the attraction?
Well, it is, but David, let's face it, the resources of our government are such that there are so many vendors to the government,
right,
and there are so few investigators and regulators that the whole system is reliant upon the honesty of the vendors, the people who are providing the service to the government, who are the contractors with the government, and without which none of these cases would be discovered if indeed people who are there, and it offends them as taxpayers and also employees of the company, to see what's going on.
Right. All right, time for our first break. We'll step aside, but as we do so, just want to remind you, you can get in touch with us, call, text, email, make it easy for you to do so. You can also find the firm of Hollis, Wright & Couch If you'll search that term on Facebook, Hollis_Wright, to find them on Twitter. So plenty of ways for you to get in touch with the firm of Hollis, Wright & Couch. Whistleblowers, how you could be rewarded for preventing government fraud. More of that's coming right up.
I'm Josh Wright with the law firm of Hollis, Wright & Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
Welcome back in to The Attorneys. Appreciate you being with us. A couple of more segments left, so plenty of time for you to get your questions to us, and some interesting ones that we're going to get to here in just a bit. Who actually can bring whistleblower action?
Any person who has material information, knowledge that a person or firm is making a false statement to the government for payment, can bring that action. But it's important to emphasize here, David, that the law is not kind to people just who walking down the street thinks that the XYZ company is doing something fraudulent. In order for the government to be interested and for there to be a possibility of an intervention in a complaint, that person has to have material facts that suggest illegal conduct. So we like for our relators to possess information generally from inside the company, because the credibility of the relator bears upon whether or not A, the government's going to intervene in the action, or B, the amount of recovery that the relator can expect. And I'd like to address that just for a minute. The False Claims Act says that a relator is entitled to no less than 15% or more than 25% of what the government collects. Now, for every dollar that the government is illegally paying as a result of the false claim, the government is entitled to get back 3 times that amount. So it's treble damages. And then on top of that, Congress has provided a per transaction penalty, no less than $5,000, no more than $11,000 per transaction. So the numbers in these things generally are in the millions of dollars that we're talking. So you say, well, what is the relator? What can the relator expect? The average relator's recovery that the Justice Department would permit is 16%. You say, well, the statute says up to 25%. The U.S. Justice Department looks at that as a maximum 25. Right. There is, however, the possibility that the Justice Department only intervenes in 20% of all cases that are filed across the country. So here's 80% of the relators who are left out that have to decide, do I want to fight this one on my own? In the event that they do, now the ante goes up. Now the relator is entitled to no less than 25% of the recovery or more than 30%. The reason being that these things are terribly expensive.
I bet.
And if the government will not use its resources, not many relators can afford to bankroll their own actions.
Yeah. Henry, answer this for the viewers too. If the government decides not to get involved,
right,
and you've got to go on your own,
yes,
there are lawyers that will bankroll those cases for the whistleblower, are there not?
There are, but we generally see in healthcare cases is the one that is rampant right now. You've got to employ experts, and experts have to review medical charts. And the going rate for many of those, because you have so many medical charts, and each chart is thousands of pages sometimes, so you're talking $100,000 per expert. And relators nor lawyers just want to be able to bankroll that kind of expenditure. Plus, you've got to take it through full trial and appeal and so forth. So the optimum is to have a case that is meritorious on its face, that the Department of Justice, along with the agency it represents, can take, investigate, and intervene and take it. Now, 95% of all cases that the U.S. government intervenes are either successful to its fruition or settled by the company. The reason is clear. Who can afford to deal and to fight the U.S. government with all of its resources when you've done wrong?
Is there an advantage to go to a firm like yours that does this type of litigation because you have a relationship with individuals at the Department of Justice to try and get them to get involved, or is that a totally independent decision that the DOJ makes?
I think it's a combination. I think when you've been in this kind of work as long as we have, we do establish our credibility with the Department of Justice. We have cases literally from Washington State to Florida, and we deal with assistants United States Attorney throughout the country. And like every facet of our society, there are good AUSAs, and then there are AUSAs that'd rather be prosecuting bank robbers. So we know who is the squeaking wheels are that are going to get the grease.
Fair enough. Fair enough.
A question we've got here: if I hear about fraud on the news or read about it in the paper, can I attempt to bring a whistleblower lawsuit?
Absolutely not. The law prohibits public domain disclosures. You can imagine how many people would run to the courthouse if watching tonight's news on WVTM, they found out that somebody had been raided by the FBI for some illegal activity. No, this is a law that is strictly limited to people who have knowledge and facts, and they have to be also the first to file.
Okay.
You cannot, there can't be a multiplicity of lawsuits against the same defendant.
Yeah. All right. Time for our second break of the evening. As we do so again, would love to remind you how you can get in touch with us. Call, text, email, find the firm of Hollis, Wright & Couch on Facebook as well as Twitter. Stay tuned. More of the attorneys coming up right after this short break.
I'm Josh Wright with the law firm of Hollis, Wright & Couch. Now, serving on a jury can be confusing because there's some information that the attorneys in the case aren't allowed to tell you about. And in a wrongful death case, it might surprise you what information can come in. In tonight's Legal 4-in-1, we're answering the question, what evidence is allowed in a wrongful death case? That's a case where one person's conduct caused the death of another. A wrongful death case is a civil cause of action for someone's death where money damages may be awarded, not jail time. In these cases, a lawyer can only talk about punishing and deterring the defendant for causing the death. That leaves out a lot of information about the person who died, including how that person's death has affected his family and his community. The reason lawyers only talk about punishing and deterring the defendant in these cases is this. In a death case, at the end of the trial, the judge will read a jury charge which says the damages in this case are punitive and not compensatory. Punitive damages are awarded to preserve human life, to punish the defendant for its wrongful conduct, and to deter or discourage the defendant and others from doing the same or similar wrongs in the future. Now, this means that in Alabama, lawyers can't talk about how great the loss was to his family or friends. They can't talk about the lost wages or the financial impact on that person's family or the person that passed away. Lawyers can't even mention how much that person loved his wife, kids, or grandkids, or what it would have meant to walk a daughter down the aisle or attend a prom. In short, lawyers can't talk about all the things that person who died at the hands of another missed out on in his own life. In Alabama, the legislature has said you can't put a value on someone's life. So as lawyers, what we can do, the only thing we can do, is ask that the defendant is deterred and punished for the wrongful conduct that caused the death in the first place. We can ask that a jury send a message, a loud message, to prevent such types of death in the future. As an example, if a truck driver caused a crash where someone died, the jury can send a message, a loud message, to that truck driver by making the truck driver pay money damages. The hope is that other drivers will be discouraged from the dangerous conduct that caused the death in the first place. As attorneys, we often wish we could submit more evidence to the court about the person who died, but unfortunately the rules don't allow it. If you ever have been a juror on such a case, please keep that in mind, what we've told you today. Remember, your call, email, or text to the attorneys is free. All of us at Hollis, Wright & Couch want to help answer your questions on real issues you face. A competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks on Sunday nights for watching the attorneys right here on Alabama's 13.
A lot of ground to cover, and we're about 4.5 minutes remaining. They will answer every email. The firm of Hollis, Wright & Couch will. So the information you see on your screen for an email, you can still email those questions in, but flying through the time tonight.
Yeah, you know, Henry, one of the things that we have not discussed is the time frame within which you learn of a fraudulent act and have material knowledge of it to the time that you have to file. What's the breakdown there?
6 years by individuals. If the government intervenes, however, the government can take it back as far as 10 years. Right. But for the individual relator, we're looking at 6 years.
And are there other types of examples of suits that you're seeing now?
Sure. You know, under the Tax Relief and Health Care Act of 2006, there are, heretofore, the IRS had a whistleblower provision, but that those numbers have increased as far as what the relator can recover. That's the good news. The bad news is that Congress has said, yes, there are whistleblower provisions under that act, but only if the tax penalties and interest are over $2 million by a person whose gross income exceeds $200,000. That's one area of practice that whistleblowers can recover. They can also recover in the securities field under the Dodd-Frank Act. Heretofore, the whistleblower provisions in the securities area was only limited to insider trading. Now, after the recent events in the banking industry and securities industry, that has been under the Dodd-Frank has applicability now to securities fraud throughout.
You recommend if somebody has seen something like this at work, they have material information, they get with a lawyer.
Absolutely.
Walk through it. And then you don't charge to consult and work through these issues with folks?
No. Our consultations are free. We have to vet these things before we file them.
Right. Very important to get with lawyers on this.
Just a couple of minutes left, but a couple of questions maybe. Can I keep my identity a secret if I file a qui tam action?
Great question.
Well, yes and no. Yes, your identity will be kept a secret so long as the case is under seal. And you know, we said they average 2 to 3 years being under seal.
Right.
After the seal is lifted by the judge, then it becomes a public record,
Right.
and then the whistleblower's identity is known at that point.
All right, and quickly, my neighbor's cheating on his taxes. Is that covered under FCA?
No, it's not. As I said, it's under an IRS provision where the tax owing has to be at least $200,000. That's tax penalties and interest.
Can't blow the whistle on your neighbor.
No.
Hey,
well, you can if they make more than $200,000. They owe more than $200,000 in tax.
Right. That's right. A minute left. How about a final thought from you for our viewers?
Well, I think this is a very important area of our law now. Particularly with Medicare being assaulted, it's open season, unfortunately, by Medicare cheats.
Right.
And we are very vigilant about that.
Yeah. All right, Josh.
All I'd say is I think you need to get with a lawyer that knows these topics. Henry's firm is a great example of that. And at the end of the day, you know, this is about efficiency. It's about creating efficiencies in government. And if you don't have the weight of the government behind you, you want to make sure you've got someone like Henry behind you. So we really appreciate you coming on.
My pleasure.
Being with us today.
And we appreciate you being with us as well. Thanks so much for the time. As we wrap things up, ways you can still get in touch with the firm of Hollis, Wright & Couch. Thanks for being with us, and we'll see you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis, Wright & Couch.
A lot of ground to cover, and we're about 4.5 minutes remaining. They will answer every email. The firm of Hollis, Wright & Couch will. So the information you see on your screen for an email, you can still email those questions in. But flying through the time tonight.
Yeah, you know, Henry, one of the things that we have not discussed is the time frame within which you learn of a fraudulent act and have material knowledge of it to the time that you have to file. What's the breakdown there?
6 years by individuals. If the government intervenes, however, the government can take it back as far as 10 years. But for the individual relator, we're looking at 6 years.
And are there other types of examples of suits that you're seeing now?
Sure. You know, under the Tax Relief and Health Care Act of 2006, there are, heretofore, the IRS had a whistleblower provision, but those numbers have increased as far as what the relator can recover. That's the good news. The bad news is that Congress has said, yes, there are whistleblower provisions under that act, but only if the tax penalties and interest are over $2 million by a person whose gross income exceeds $200,000. That's one area of practice that whistleblowers can recover. They can also recover in the securities field under the Dodd-Frank Act. Heretofore, the whistleblower provisions in the securities area was only limited to insider trading. Now, after the recent events in the banking industry and securities industry, that has been under the Dodd-Frank has applicability now to securities fraud throughout.
You recommend if somebody has seen something like this at work, they have material information, they get with a lawyer.
Absolutely.
Walk through it. And then you don't charge to consult and work through these issues with folks.
No, our consultations are free. We have to vet these things before we file them.
Right. Very important to get with lawyers on this.
Just a couple of minutes left, but a couple of questions maybe. Can I keep my identity a secret if I file a key tam?
Great question.
Well, yes and no. Yes, your identity will be kept a secret so long as the case is under seal. And you know, we said they average 2 to 3 years being under seal.
Right.
After the seal is lifted by the judge, then it becomes a public record,
Right.
and then the whistleblower's identity is known at that point.
All right, and quickly, my neighbor's cheating on his taxes. Is that covered under FCA?
No, it's not. As I said, it's under an IRS provision
Right.
where the tax owing has to be at least $200,000. That's tax penalties and interest.
Can't blow the whistle on your neighbor.
No.
Hey,
well, you can if they make more than $200,000. They owe more than $200,000 in tax.
Right.
That's right.
That's right.